Morning to those joining us. And to admit people in here. I'll get started in just one more minute. All right. Good morning, everybody. I'm Tracy Kozloff, Deputy State Engineer from the Division of Water Resources. Thank you for joining our webinar this morning. This webinar is really just to supplement a memo that was put out as a draft, I guess just earlier this month. So hopefully folks have gotten to take a look at the memo. My plan today, I have got about 20 slides here. So I just plan to run through those slides. I'll ask, for the most part, I'd like for folks to just hold their questions till the end, unless there's something that needs to be stated beforehand. And that's just because I think that, maybe as we go along in the slides, that your question might get answered. We did put out the memo as a draft with the hope that if people do have suggestions, questions, or input, that you'll bring that to us. You can email that to me directly, and we'll consider that information, consider if any changes are necessary. But without any, I guess, further intro, I'm going to continue along. Sorry, my screen just went away here for a second. So let it come back. And I think somebody's been letting applicants in, which I really appreciate because it's distracting for me to go into the Google Meet to let people in. So thank you for doing that. So the background is, what is it that we're talking about? We're talking about return flows. Here's an image from Colorado's most recent water plan explaining what return flows are. And that is when we divert water from the stream for beneficial use, a portion of that water is consumed, and then there's another portion that returns to the stream, and then water users downstream of where that water comes back use that water for additional beneficial use. So return flows, of course, are an important part of our system of water rights and water use here in Colorado. The reason we felt we had to or wanted to put out this memo is that in recent years, there's been a relatively new type of claim in the water court And those claims might say something like appropriate and or not replace the return flow portion of the water rights in a change of use case. So, we've got this new type of claim, and I know at least DWR has not always known how to consistently deal with this type of claim in cases, and we wanted to look further into it and then put out our perspective for consideration by the water community. Why the memo? We felt that there's a lack of consistent approach to the way these claims are handled in court cases. We wanted to provide clear and consistent direction to our staff in their activities around these types of claims to appropriate return flows. And then lastly, we wanted to explain and make public DWR's understanding about these types of claims, and also make public our planned approach in water court cases around these types of claims. I want to be clear about some things that the memo does not do. It doesn't change the requirement to replace return flows in time, place, and amount that I think that we're all used to. It doesn't attempt to change existing decrees. And lastly, it doesn't change DWR's water administration practices for current decrees. I felt that maybe I ought to spend a little time describing how the diagrams and the color coding in the memo work. So consistently throughout the memo, we're using this color scheme. And what we're doing is trying to represent the different portions of water under a diversion under a senior water right. So you've got the entirety of the diversion under a senior water right, and then you can break those diversions under the senior right into different proportions that total up to the total diversion in general. So you've got the consumptive use portion of that diversion, you've got the ditch loss, and you've got immediate and delayed return flows. And so in this PowerPoint presentation and also in the memo, we're just have some diagrams that are using this color coding to represent these different portions of the water. So, of course, when we are looking at a historical irrigation operation, we've got the diversion from the stream system. But then when we look, I guess, at the life cycle of this diversion, the amount of water that we divert is split into those different portions. You've got what becomes the irrigation consumptive use. You've got the ditch loss and both the immediate return flow and delayed return flow. And so, you all are probably familiar when we're dealing with a change case. We're thinking about all these different portions of the diversion. So jumping into the major points of the memo, takeaway number one, water that historically returned to the stream under the exercise of a senior right, which is return flow, is owed to the stream as the waters of the state to be available for appropriation. So when we think about that irrigation diversion that we were looking at just a couple of slides ago, and then we think about it in the context of wanting to change that senior water right to a new type of beneficial use, what we're going for is taking that diversion under the senior right, generally taking the historic consumptive use portion to a new use under the change of water right. But we also have to think about all these other components of that diversion. So you've got to think about the ditch loss, and then you also have to consider what's going to happen with the return flows. And generally, I think we're all used to this premise that return flows need to be replaced in time, place, and amount in the same way that users on the stream experience those return flows under the irrigation use of that water right. And so this is one of our diagrams from the memo. It's showing one potential way that under a change of use case, delayed return flows would be maintained in time, place, and amount. In this particular scenario, the method of maintaining return flows in time, place, and amount is that the return flows are going to be taken down the ditch under the senior water right. They're going to be stored in a reservoir, and then they're going to be released later on with the appropriate timing, matching the historic timing, and then shepherded to that historic return flow location indicated by a star in our diagram. So this is just, one method. We're maintaining those return flows in time, place, and amount in a change of use case. So, I think for probably all of you on the call, you're all very familiar with this type of operation. And so this is just sort of background information for you all. So then again, in this situation, I've just included a 1920 diversion here, added this diversion to our diagram. And so that's an existing water diversion entitled to the maintenance of those stream conditions, and might be one of the entities diverting water from the stream that includes those return flows that were released from the reservoir with the appropriate delayed timing. So moving along, the second takeaway from our memo is as follows. Appropriators junior to the change case, junior water rights, are not entitled to the maintenance of stream conditions that existed before their appropriation. But nevertheless, the applicant in a change case must make return flow replacement available as waters of the state when there are unsatisfied water users. So DWR thinks that decrees could allow flexible location and timing within reason to replace return flows when it is only those junior water rights who aren't satisfied on the stream. So if we go back to the diagram that we were looking at last time, the difference is here that rather than a water user downstream of the return flow location whose appropriation occurred before the change of water right, our situation now is that we only have a water user downstream of that return flow location that's junior to this change of water right. So as I had said before, appropriators junior to the change case are not entitled to the maintenance of stream conditions. It doesn't need to be exactly the same as what occurred before they made their appropriation. But at the same time, the applicant in the change case still has to make return flow replacement available as waters of the state when there are unsatisfied water users. So in this situation, we have a junior water user, junior to the change case, unsatisfied. So the change applicant needs to make those return flows available to these junior water users, but not necessarily with the same historic pattern. In a situation like this, the applicant in a 2023 change of water right case may make a new 2023 appropriation of waters of the state. That 2023 appropriation could be at the dam of a reservoir where water is stored for return flow replacement, or below the point of return flow release to the stream. The change applicant must make water available for appropriation, but if they have the best priority on the stream at the time that replacement is owed, they may divert under their 2023 priority. So if we look at the same diagram, it's the situation I was just describing. But if the applicant in a change case wants to, they can make a 2023 appropriation of waters in the state within the reservoir. And if that's what they do, they might have the best priority on the stream and be able to keep that water in their storage reservoir because they have a more senior priority than the downstream 2024 diversion. So essentially, when we've seen all these different ways of claiming to appropriate return flows or not replace flows, this situation I'm showing here in the diagram was the one limited situation where we saw that an applicant in a change case can make their own independent appropriation and then be able to retain that water in their storage reservoir under that junior appropriation in accordance with the priority system, because they're making a new junior appropriation of waters of the state. So, this was the most basic scenario that we're looking at in the memo, but we could get more complicated, and certainly a lot of you are probably aware that situations and changes of water rights can be complicated. But takeaway number 4 that I wanted to highlight is that our thinking is that when there are multiple replacement sources and unsatisfied water rights junior to the change case, we think at a minimum, decrees should ensure that when there are unsatisfied water rights below the most downstream return flow replacement location, that water needs to be made available for use in priority. But courts and parties to a specific case might be the best to determine the particular requirements in these complicated situations for when and where water needs to be released for these junior water rights. Lastly, our memo does address DWR's concept around these types of change cases in Free River. We think that under Free River conditions, decrees need to govern if water needs to be released to replace return flows. So even though there's no unsatisfied water right downstream of your return flow release location, whether or not that needs to occur is going to be governed by what the decree says. However, DWR does not intend to seek decree terms that require replacement of return flows when there's no unsatisfied Colorado water rights. And that's because we see that that could lead to a waste of water because there wouldn't be any need for that water below the point of release. So with that was my last slide. As I had said before, hopefully a lot of you have gotten to review the memo. If you haven't, it's available on our website. We'd like to hear from others if there are any questions or input, suggestions for the memo, anything we might have overlooked. But otherwise, happy at this point to open it up for questions or input.
Hey, Tracy, can you put a link to the memo in the chat? Some people have requested that. Thank you.
You bet. Thanks, Paul. Steve, I see you have your hand up. I'm going to also try to quickly get a link to the memo too to put in the chat. So give me a second before you start with your question or your input.
Tell me when you're ready.
Okay, thanks. Sorry, folks. Give me just a second. I probably should have had this ready.
Tracy, I just put it in the chat.
Okay, thanks. I appreciate that. Okay, Steve, please go ahead.
Throughout your presentation, you talked about water being available at the dam. Yet you've also talked about water delayed return flows being stored. I assume the use of a dam includes storage facilities that didn't have dams, like gravel pits.
Yeah, you're right. I guess I was just using the shorthand term of
Okay,
dam.
I'm just trying to figure out internally if this only applied to on-channel reservoirs or if off-channel reservoirs storing delayed return flows, the same ideas would apply.
Yeah, I think the same idea applies. I think you can make that water, those return flows available as waters of the state in the gravel pit, and then you make that appropriation there. I don't think it matters.
Would you anticipate that if your delayed return flows were, let's say, due in the non-irrigation season, that you would want to see water physically available at the head gate that could go to that storage vessel in order to cause the appropriation to occur? In other words, if there was no water at the head gate, but you had water stored in the reservoir, could you in fact appropriate water in a reservoir that had been diverted under another water right instead of a 2023?
So if you had, I'm not sure I followed your question, but
Let me rephrase it, and
Okay.
maybe I could do better. I mean, typically a water in a change case is diverted under a very senior water right. The delayed return flow portions of that could be stored in a reservoir.
right.
What you posited is that if there was no downstream call or a free river condition, the water in the reservoir could be appropriated under a junior water right. And what I wanted to know is if there were any other conditions to that. In other words, would there have to be water available at the head gate that would be the inlet to the reservoir or the gravel pit where the water was stored? I'm just trying to tie it up with traditional Colorado notions of appropriating from a stream.
Yeah. So no, I don't think so. I think what you're doing is you're making an appropriation in the reservoir. And if you didn't have that appropriation and there was a downstream call, let's say it's then 2024 downstream call, let me back up. You're actually going to make that water available as waters of the stream in the reservoir. And then you're making a 2023 appropriation of waters in that reservoir. And if you didn't do that, and there was a 2024 call downstream, you'd have to release from that reservoir the return flow portion to meet that unfulfilled water user downstream. It's just
One
that,
more.
sorry, if I could just add, and I thought I was trying to make myself more clear that you as a change applicant happen to have made the 2023 appropriation there, which is then more senior than the downstream 2024. So under the priority system, you can keep that water under your 2023 appropriation in the reservoir.
One follow-up, and then I'll let others ask. But
Steve, if I could interject here real quick, that I think this might help the whole group, is the way the engineers view that return flow component. They view it as being water that's owed to the stream as waters of the state, and it's sitting in the reservoir. And so based on the historical pattern of returns, you would be releasing that at a certain time. But rather than release, you're just going to keep your gates closed, and the engineers are going to consider that a diversion of water that would otherwise be released into, consistent with the historic pattern. So they're recognizing that not releasing water that's owed to the stream constitutes a diversion in this context, which is sufficient to support an independent appropriation of waters of the state at that location within the system. So that's how they are looking at this situation. There is an independent appropriation based on a diversion because you're closing your gate and keeping it closed. and when you otherwise would be paying that water back to the state.
And Paul, thank you for that explanation. I understand it's a very practical approach, and I certainly appreciate that. I'm just wondering, I mean, normally, if there's waters of the state, anyone can divert them. Does that mean that anyone can go into my reservoir and seek to divert the water? Or do I just get first dibs on water in my own reservoir?
I guess I'll take a stab at that and also see if, Paul has any different thoughts. And for those who aren't aware, Paul Bennington is our Attorney General, our representative in the Attorney General's office, and did support us in the development of this memo. And so I guess with that, Steve, I just don't know that it's appropriate for some other entity to try to make an appropriation within a reservoir that they don't have permission to use. But if they were to make an appropriation downstream that happens to be then senior to whatever appropriation the change applicant makes in their own reservoir, then that entity with the downstream more senior priority under the priority system should be provided with that return flow quantity of water just based on the priority system. But basically, I just don't know that it's appropriate for any other entity to make an appropriation within someone else's reservoir.
Thank you, Tracy, for clarifying. And Paul, this might be our last opportunity to thank you for all your years of service at the Attorney General's office. I understand you're retiring in June. Thanks, Paul. You did a great job.
Thanks, Steve. I don't. I appreciate your comments and everybody's well wishes. And I just wanted to add, Steve, on this issue that it's common in reservoir administration to have water that's owed to the stream that we basically consider waters of the state. The particular issue you raise about somebody else coming in and trying to claim that using your structure, I think is a bridge we'll cross when you all get to it. But yeah, it does raise the specter of that. But ultimately, as water's owed to the state, you'd have control over that reservoir to release those as you see fit, or absent some superior right.
Thanks, Steve, for your questions. Jeff Clark, I see you have your hand up.
Yes, thank you, Tracy. I appreciate all this information. My question is part of the topic that we've just been talking about. I was going to ask you to talk about the state's position on if you're going to appropriate it like a brand new appropriation, if you could talk about the policies on that. A piece of that is water in a reservoir that we just talked about. Another piece that I see in your memo talks about proof that water is legally and physically available. And if it's already in the reservoir, how do you need to prove that it's legally and physically available? When technically that's still in your dominion and control, I would think. And then you also talked about can and will and being able to put that to beneficial use. Could you talk about retained return flows in light of those other aspects of a new appropriation, please?
Yeah, and so are you asking about, there's a listing on page 6 of the memo about essentially all of the requirements to make a new appropriation? We list, it's under 6A through F, all of the requirements to make a new appropriation under Colorado water law.
Sorry, if you're asking me to confirm, yes, that's the section I was talking about.
Yeah. So we see that there's essentially, I guess, 2 steps when you're making the appropriation of water that you have stored that you would normally be releasing to make return flow replacement. The first thing you're going to do is essentially you make that water available as waters of the state for appropriation, because, you know, that is one of the requirements, is that when you're doing a change of water right, the change applicant is not entitled to just use those return flows. They have to be made available for appropriation. So that's going to be step one, is you're going to make those waters available for appropriation, but that's going to be within the reservoir itself. And then if you have made that new 2023 appropriation, and if you have the most senior unsatisfied beneficial use at that moment, then you're going to actually get to appropriate those waters of the state in the reservoir. So, you know, those things are all happening really at the same time, but there really are two steps. You're making that water available for appropriation, and then you're actually going to appropriate it, as Paul said, by keeping your gates closed and keeping it within your reservoir, assuming you're the most senior at that point. So, you know, I don't know that there's much more of a showing than the fact that you're going to go through those steps of that water is available for appropriation, because you're essentially making it available as waters of the state. There is water in your reservoir, and then you, having the most senior right, are going to be the one to use it.
And I think to put a finer point on that, Jeff, I think you would need to show that, you know, there are going to be times when it's basically free river down below you, or no call senior to your right calling below you, such that you can perfect it. This type of thing might not work well in the Arkansas, you know, where there's a year-round downstream call for the last 20 years. You might not be able to make such an appropriation without a plan for augmentation. You know, in the South Platte, I think you would need to show that there are times when you would be able to retain that water in priority as part of your claim for what will probably be a conditional appropriation, that you can perfect it with reasonable diligence, within a reasonable amount of time, for non-speculative purpose. You know, all those requirements. It'll probably be a little easier in this scenario, just by showing that there was no call when you retain that water, no call senior to you.
Any other questions? All right. Well, I'm not seeing any. You know, as our announcement said, and as our webpage says on DWR's website, I do welcome any kind of written input that people want to provide. I've asked for folks to please provide that by the end of May. If there's anybody who needs additional time to think about it, you know, you can reach out to me and let me know your thoughts, and what type of reasonable timing you're going to need to provide input. But outside of that, I just want to say thank you to you all for your attention. I'll put the presentation slide back up here just so you can see my email address. That's where I'd like folks to go ahead and provide input if you do have it. So let me bring that back up in case anyone needs to write that down.
And while you're doing that, Tracy, I just want to reiterate, DWR, you know, wanted to share this approach as to how they're handling cases going forward. They don't see, you know, existing decrees, they don't anticipate, or, you know, they don't think will be affected in any way. Those decrees provide what they provide. So this is kind of their forward-looking approach. Do you want to add anything to that, Tracy?
Yeah, I think that's just a good thing to reiterate. We're not looking to change administration or existing decrees, but we would like to reduce some of the confusion that we've been involved in these types of court cases that involve these types of claims. And so our hope is that putting out this memo can bring us together, I guess, as a water community around these types of claims. And yeah, I guess I'll leave it at that. Thank you. Brent, I see you have raised your hand.
Yeah. Hi, Tracy. Hi, Paul. Thanks. Quick question on Paul's term on understanding that this is the approach moving forward. Of course, there's pending applications that have been following what we understood was the rule of the state, needing to make the claim for appropriation rather than technically calling it a new water right. I could see that terms and conditions could be included to treat it as an appropriation of a new water right, but going back and having to amend the application to change the wording from the claim for appropriation, is that something you're looking for too, or have you thought through that?
So are you saying that right now you're thinking about an existing case that has a claim that says a claim to appropriate return flows or to not replace return flows?
That's correct.
You know, I guess I want to rely on Paul here because that seems to me that I'm not sure if you've made the appropriate notice to the water community if you do want to make a new appropriation, but that might be case specific. I don't know, Paul, if you have any guidance on that.
Yeah, my understanding is DWR is not providing the or taking the approach of having some sort of transition period here. They, you know, as I think some of you are aware with the water exchange project memo that the engineers put out a while back, they kind of announced that they were going to start implementing that after a date certain for applications filed in a certain year. I don't think that's the case here, Brent, because they've been taking similar type of positions in pending cases for a while, and Judge Hartman's ruling that came down in Division 1 has been guiding that to some extent. I think, you know, and the engineers have been trying to be true to that ruling. I think where the engineers part from that ruling a little bit is by not compelling replacement during Free River if there's nobody calling for water downstream. So to the extent people are asking for terms and conditions like that in their current decrees, I think the engineers are going to be fine with that. But some of these other claims that are out there aren't really independent appropriation of return flows. They might be claiming some rights in the return flow components, but I think the engineers are going to continue to push back on some of those claims because they just don't think those are true water rights or true appropriations that should be recognized. I think Judge Hartman's ruling's been out there for a while.
The 16 CW 2300, it was a 2019.
3,200.
3200.
And so I think the other thing that Judge Hartman said is that, look, you need to replace to protect future appropriators, you know, that should be able to pick up that return flow water. And we agree with that, but we're also recognizing that the change applicant might be one of those appropriators. And it's okay for the change applicant to put in to appropriate that water as one of the future appropriators. So that's where we're trying to strike the correct balance there, recognizing that the change applicant's one of those appropriators Judge Hartman was referring to in his memo. And, you know, I think, and just for the water bars, I guess, general knowledge, you know, Judge Hartman was really in that decision, had a certain set of facts in front of him and was looking at diversions at the head gate. Nobody spoke to him or argued about this being able to do an independent appropriation at the point of the storage where those return flow waters are kept. And so some of the issues we're dealing with now, we're not in front of Judge Hartman. And so we're trying to find a way to do it in a rational and legally sound way. But I don't know if I answered all your questions, Brent.
I guess I just add, Paul, and this is something that we didn't touch on directly, but an applicant in a change case could certainly file a subsequent application for a junior water right. It doesn't have to happen at the same time as the change case, and I realize that's maybe not the most convenient, but no reason why you couldn't, at this time file an application to appropriate waters of the state in a reservoir if that's your situation. So. Eric, I see you have your hands up.
Yeah, thanks. Sorry, my camera's not working at the moment, but I was wondering if you could walk through the state's position on how the appropriation of the immediate return flow component would work. I know that typically that'll take care of itself when there's a downstream call, but say if it's early on in the year, say during runoff, and the changed water right is diverting and there's not yet a call in the river, how does the appropriation of that immediate return flow component work?
You're asking a question, Eric, that I hadn't really thought of, because in my experience, I guess we've been mostly dealing with the delayed return flow portion, but I guess I don't see why the immediate return flow portion can't be made available as waters of the state and then appropriated by the change applicant with a new junior appropriation. In the same way,
Kind of where would that location be? I think conceptually it makes sense, but where would my client or whoever claim the point of diversion to be if it's not being stored in a reservoir like the delayed component?
Yeah, Eric, you would need an independent diversion. At that point, it's really just waters of the state. And if you can appropriate waters of the state by diversion in priority, then you would do that downstream. But the that immediate return flow water is typically diverted under the senior priority and returned to the stream right away. And so as soon as it hits the stream, it's just waters of the state available, and you would only be able to appropriate that if there's no one downstream that's unsatisfied. But you would need an independent appropriation, which would require a diversion.
So in the state's view, this sort of forecloses the way many decrees used to be done, where the change applicant was able to sort of divert the entire amount and just use that for new uses and address return flows with other water rights if there's a downstream call.
You can still do that, but you would still be providing that immediate return flow and lagged return flow from those other sources. So you'll still be able to divert the full amount as long as you're maintaining what's owed to the river.
I guess I'll give that some thought. Thanks.
Yeah.
And, Eric, I don't know if you got to read the memo yet. We have, even though I didn't address it in the presentation, example 2 is an example where at least the delayed return flow portion was taken to the new beneficial use, and then replacement of those delayed return flows was made from another source. Really just hadn't thought about a situation where immediate return flows were also, I guess, used for beneficial use and replaced from a different source. But we weren't intending to say that an applicant can't use return flows if those return flows are replaced from a different source.
Yeah, and to fill that out a little bit, Eric, it may be, when you divert the full amount, at one location, and you have water in another bucket that is going to cover both the immediate and the lagged return flows. If there's no call, So as soon as you divert that full amount, then you have owed to the river water in that other bucket. And if there is no call, you might be able to appropriate all the return flow component in that bucket at that time.
Under a new junior appropriation.
Correct. I hope that helps. So it's really tracking what's owed and where it's to be paid out of. And some people can pay it out of a number of buckets. And Tracy tries to address that situation, and you have some flexibility as to, where you might appropriate that water and when, depending on the call regime.
And I guess I'll just add that I appreciate the questions, because there's probably scenarios that we didn't think about that you all are thinking about with your clients. And, if we can be more clear about our position, considering the various potentialities, I guess I'd like for us to do that in the memo. We don't, the point is to reduce confusion and improve clarity. So if we can do that, then let us know how we can. Thank you. Andy Hall.
Hi, Tracy. So I just am trying to figure out or picture what this would look like on paper. So you talked about these two steps kind of happening at the same time, making the return flows available and then the separate junior independent appropriation. So even though they're kind of happening at the same time, would you want that separated out? So you'd have your change and then your junior appropriation that would reference the water made available through the change in the return flows?
So in terms of a water court application, I do think you've got a separate claim there for making a junior appropriation of waters of the state and the reservoir. I guess I don't have a strong opinion, maybe Paul does, about if a decree really talks about the two steps, that I was talking about earlier today, the step of one, making that return flow portion available as waters of the state and the reservoir, and then secondly, diverting or storing under your new junior water right that you've made. But I don't know, Paul, do you have any thoughts on how to be clear about that?
Yeah, I think, it's probably going to vary depending on the water user, because, some people may just want to do a new appropriation at the dam of available waters of the state, and it maybe will include the ode to the river water, but it might include some other sources as well that might be accruing to that reservoir. So I think certainly your claim can explain why there's going to be water available there, because there is some ode to the river water under a change case that you intend to retain in storage. But you might have to want to explain other sources that you want to include in that same new junior appropriation.
Okay, thanks.
Anybody else? All right. Well, thanks everybody. Looking forward to hearing from people via email or phone as well. So thanks for your attention and the good questions. Hope you all have a nice day.
Thank you. Bye, Trace.
Bye. Thank you, Paul.